Happy Tuesday, Excellence family. I am here with our title attorney, Paul Sarone, and have a few minutes to catch up with him regarding some concerns when you have title issues that come up, judgments for the seller, other things that could possibly be deal breakers. But according to Paul, they are not, and we can definitely help. Hi, Paul. Good morning. How are you?
Good morning. Great. How are you doing?
Doing well, doing well. I thought it'd be great if you could share with us, some of the, I guess, pitfalls that occur when you've got sellers that have issues out there.
Right.
How can we smooth things over and clear things up for the buyer and keep the deal alive?
Yeah. So unfortunately, that does happen sometimes where you have sellers that may have various judgments against them, things like credit card judgments. Maybe they got sued by somebody, or somebody slipped and fell in their house or their business, and they have these judgments that are following them around. And sometimes it could be an obstacle when they know it exists for the agents, for you guys that are trying to get a listing, because people say, well, I can't sell my house because then I got to pay this. And other times it's just a surprise. We pull title, and a bunch of credit card judgments come out, and the seller's like, well, I didn't know that affected my property. And the answer is it may or may not. That's why, that's what we're there for. And that's why it's good to work with experienced title agents and attorneys, because there are protections in the state of Florida when the property is the seller's homestead, for example. So let's say you take a listing and get a contract, send us the title work, we pull it up, the person owes American Express $20,000, let's say. That comes out, and then that person's not going to be happy that they have to pay that off. They probably thought that was just going to linger there. Maybe they were going to file bankruptcy at some point, or they just forgot about it. It was years ago. Well, there are ways that if it is the seller's homestead property, we could file an affidavit of homestead on the case and put the creditor on notice. And then when it is your homestead, you are protected from having to pay judgment creditors, so they could sell without having to pay that off. Florida has great homestead protections. That's why, a lot of people like to own real estate here, and a lot of people, particularly with a lot of exposure. The most famous one being when O.J. Simpson moved here after he knew he was going to get sued. He knows that nobody can touch your house, and even if you were to sell it, any civil judgment, any credit cards, things like that, do not impact your ability to sell and receive all the proceeds. Now, whether they can go after wages or bank statements, that's another topic for another day. But what we're concerned about is being able to take these listings for people and being able to close deals when these issues do arise. Now, if it is in a homestead property, then you run into issues where you may have to pay it off, you may have to settle it, or we have had cases where maybe there's not enough money to pay it off, or they're just going to eat all their proceeds. And we have been able to, in some cases, negotiate for a partial release. So the person doesn't get released, but they release our property as to the judgment. So they may say, let's say in the scenario where Amex is owed 20, even though Amex is one of the tougher ones, they probably wouldn't do this, but sometimes smaller creditors, let's say they're owed 20,000, maybe we'll say, hey, we'll pay you 5 out of the closing and just issue us a release so that we can give the buyer a clear title, not subject to those judgments. On the flip side of that, going a little bit off topic, but also related, that's one of the dangerous things when people do quitclaim deeds from one person to the other, because you think, oh, I'm going to add, my daughter, I'm going to add my son, I'm going to add a friend in case something happens to me. That person's, all their stuff now attaches to your property too. So if you're adding your son, let's say, or who's, let's say, 23 years old, 24, maybe he took out credit cards in college, not knowing that the interest rates on them, and defaulted and now has judgments just by adding that person on the title. Now, when you go to sell, their judgments are also on the title, and they may not live there. So you may have to pay off their credit card. That's why when I do a lot of consultations for estate planning type of stuff, where people are trying to leave property to their kids, I usually, when that's the only thing they have, I usually recommend against adding, young children to title, because anything could happen there. Especially if they don't live there, they could get sued, they could get married and divorced. A
Wow.
million things could happen. So that's something to consider, a little bit off topic, but also related in that, you got to know how to deal with the judgments and the surprises that could come out in the title.
And many times there have been surprises, and I don't think people realize. I guess those creditors will go out there, or if they quit claim deed someone, didn't
Their name
into
attaches.
account.
That's happened all the
It
time.
follows them. Oh my God, I don't think people realize that they quit claim
Yeah,
deed.
we've done it. I've done it hundreds of times where I run title and then I'm like, hey, this judgment came out. Like, yeah, but that's not against me. That's against my niece.
My
I'm like, yeah, but you put her on the title, but I'm the owner. But she's the owner too. She has equal in the eyes of the law. She's the owner just like you, whether she's ever lived there or paid a bill or paid the taxes or even set foot in the property. Once you put them on title, all the baggage comes with it.
Wow, I don't think many people realize that when they do the quit claim deed.
No, that's a
Also,
very common mistake. Yeah.
I mean, I think most creditors would try to put a judgment, right? And then it's up to the buyer or the owner,
Yeah,
sorry, the
it's there.
seller.
It's there. Yeah. And then what we do is we file when it's the homestead. We file the notice of homestead, and the law in Florida is clear on it. Sometimes the creditor will push back and say, "Well, prove to me that it's your homestead." And when it's not clear, most of the time they don't even answer, and we just have to wait for the statutory period to pass for their reply, and they don't answer, and then we're clear to give title insurance and to move forward with the closing. And if they ever did come back, they have no claim because we have proof that we've put them on notice. But that's a pretty powerful tool, and we've gotten some deals closed that didn't look like they were going to close using that. And it's not easy. It's not cookie cutter stuff, but it's stuff that you do when you work with somebody who knows what they're doing.
Well, and that's why we always suggest Xcellence family, reach out to us here at Xcellence Title. Paul has a broad knowledge base in all these matters. Anything that comes up, really think clearly through what your buyer or seller is trying to do. Even you personally, I think I see a lot of people wanting to quit claim deed property, and I don't think they really think through the implications of doing that. Like adding someone on, you're inheriting all that baggage and debt, good and bad, and divorce and whatnot. So it's really important to talk to someone that knows, and that's why we're here to help. I mean, our agent concierge line, the corporate line, 305-595-7355. It's the option for title. I know that Paul is kind enough to offer his email address, paul@excellencetitle.com. Just reach out, ask these scenarios, because that way we're prepared when you enter into contract and we don't have this problem closer to closing.
Exactly.
Like you said, right? Right. So never underestimate the power of a knowledge expert to take a look at what you're doing. Like you said, some of these can feel like cookie cutter, but they're really not. And you really need to think through what you're doing before you make those changes. And you can help your seller out quite a bit and save some time in the whole legal process, right?
Yeah, exactly. You want to do it ahead of time and not be reacting. You want to be proactive and not reacting, where you're trying to fix a problem, because then that gets more complicated, expensive, and time consuming than just doing it right the first time, especially with the estate planning stuff. I know people they'll print a form online and fill it out, and then there's defects in the deed. And then when they go to sell, they need, it's just a mess. So it's better to pay somebody a little bit, get all the options and get it done right, than later have to jump through all these hoops.
I totally agree. So Xcellence family, don't hesitate to reach out to us. Paul, thank you so much for your time and your guidance. I know you've come to our rescue several times when we have issues, and we work through them and we smooth it out and make it, proper. So I would say experience the Xcellence way. Don't hesitate. Reach out to us today. Thank you, Paul. Have a wonderful Tuesday. Bye, everyone. Bye.
Bye.